Well, good morning, everybody. I hope we're all on screen and that you can both see and hear us. It's my great pleasure to introduce this webinar, and it's my greater pleasure to be able to introduce the four speakers. We have two from the UK and two from Singapore. So it's very, very international. And the topics, commodity trading frauds and title to sue, are literally topical. Commodity trading frauds seem to have suddenly emerged as a real problem internationally, and have given rise to cases both here in the UK and in Singapore as well. And so it seems sensible to look at some of the problems that arise. And in relation to title to sue, there has been a mini revolution in the courts in Singapore in deciding to depart from the House of Lords decision in the Aliakmon. So it's going to be very exciting to hear how that has come about. So it's now just past 11 o'clock. I think we should start, and we're going to start with Richard Lord QC. And Richard has been in practice now for some 25 years in commercial litigation and arbitration. He's particularly specialized in dry shipping, shipbuilding, but also insurance and reinsurance, commodities, energy, and professional negligence claims. He's appeared in all tribunals in this country and abroad, and in many arbitration tribunals as well. So without more, Richard Lord, QC, Commodity Frauds, Lessons from Recent Events.
Thank you, Richard. Good morning and good evening, everyone. And perhaps to start, I say that what enthuses me even more perhaps than interesting points on title to sue is that we are doing for the first time a joint webinar with Rajah and Tann, London and Singapore, obviously the two leading maritime law centres. What happens in each of them is of great interest to the other. I have always had a very warm welcome in Singapore, which I've much enjoyed visiting, and nowhere more so than from Rajah and Tann. So it's really great pleasure we're doing this together. Without more ado, let me move on to what I'm going to say about this topic, which we've realized is actually quite a large topic, which could occupy several webinars, but I'm going to deal with some aspects of it in the next 15 minutes. Next slide, please, Paul. And by way of introduction, as I'm sure you all know very well, the traditional structure of the international commodity sale is set up to ensure that all parties to it are protected, not of course fraud-proof or foolproof, but the role of the bill of lading and the letter of credit and the way they work have helped to ensure that. And three of the more modern developments have made trading easier and quicker, particularly in the oil trades, but correspondingly more risky. And they are the delivery letter of indemnity, which everyone is familiar with. They've been around for a long time. And particularly in recent years, a tendency towards a more liberal regime on letters of credit and what documents are and aren't acceptable under the letter of credit, including potentially stale bills and so on. And then thirdly, the willingness of buyers and their banks to accept presentation by the seller, not of a bill of lading, at least in the first instance, but a payment letter of indemnity. And that, of course, is a very different type of instrument. It's not a document of title, and it doesn't give any contractual right against the carrier. Next slide, please. So this has led, perhaps unsurprisingly, to a large number of instances where traders have come unstuck, whether through fraud or simply carelessness or over-optimism. And when the balloon goes up and everyone is surveying the wreckage, the bank, who traditionally is looking to recover losses it can't recover from its clients, looks around and for its rights, and they'll typically include its own rights or its rights as assignees of the buyer to possession of the bill of lading and to be the buyer's rights under various sale and purchase contracts. And what has happened in many instances recently, when the bank has looked to see what it can do, it discovers it may not know where the cargo in question is, or where the bill of lading in question is, or where the sale proceeds from sale of the cargo is present. And there have been a number of instances which have been well publicized and documented, as well as the subject of legal proceedings, where irregularities have been discovered in the modus operandi of traders. And in particular, there have been practices which can be legitimate, of course, but can be used for illegitimate purposes. These include traders selling or purporting to sell the same cargo twice, which is much easier with a payment LOI than a bill of lading, creating circles or chains of contracts which may be used to obtain cash flow advantages or otherwise, setting up so-called repo repurchase transactions or offsets and washouts, and as a corollary of all this, in some instances, misrepresenting the nature and structure of the underlying trades to the bank to obtain the letter of credit. So next slide, please. And this is perhaps a statement of the obvious, but when one's unpicking all this, it entails looking potentially at least 6 different types of contract: the sale contracts and the chains of those, the letters of credit, the financing agreement itself, the bills of lading, and the delivery and payment LOIs. Next slide, please. And again, at the moment, by way of overview, experience shows that one tends to get the same sorts of issues over and again, but they're all fact sensitive. And in particular, where you've got chains of payment LOIs, you may get issues as to whether the bank is in its own right, or as an assignee of the buyer, is it entitled to the bill of lading? How can it get it if it does not have it? Then secondly, when the bank or buyer gets the bill of lading and where the cargo has been discharged against a delivery LOI, can the holder sue the carrier? And what are the rights and obligations there? Thirdly, if the carrier is liable or said to be liable, what further rights do they have under the delivery LOI? Fourthly, what rights the bank may have in relation to the letter of credit, which may be an open one where no payment's been made, or one where payment's been made. And fifthly, what is the analysis in terms of the title or right to possession of the cargo or the proceeds of this sale, and we may have different situations where different considerations pertain. If the cargo is still afloat, it may be much simpler. Similarly, it may have been discharged, but still in specie, just sitting on its own in a tank somewhere, or it may have been mixed with other cargo or on-sold or consumed or whatever, and that raises its own problems. So next slide, please. We don't have time to deal with all of those now, so I'm going to focus on just two aspects. The first of those, next slide, please, is the payment LOI. And what's important on the payment LOI is to consider it, first of all, in its own right as a legal instrument giving rights to its own obligations, but secondly, in the context of the sale contract under which it is given. And one can classify the wording as either simply verbiage or recital, or representations, or warranties, or both or neither. And the highlighted in first point is that usually there's a representational statement that the seller is unable to provide the shipping documents, including the bill of lading, and that's a representation that they and valid ones exist. And that also the seller is unable to provide them. Next slide, please. Then typically there are warranties, both as to title to the cargo itself and to entitlement to receive the bills of lading. Those are related but separate, and again may give rise to litigation under either of those. Then next slide, please. And the third key element of substance, apart from the provisions on expiry of the LOI and law and jurisdiction, is in relation to undertakings as to how to deal with the bills of lading. The premise being, of course, that the giver of the LOI doesn't have the bills at that stage, but has the rights. And there's the undertaking both to make reasonable efforts to obtain the documents and then surrender them to you. And one has to bear in mind that these LOIs are often given in conjunction with delivery LOIs, where there's a corresponding undertaking to surrender to the carrier. And also of significance is that this type of provision is not always included. So sometimes you get LOIs that don't contain any undertaking to surrender. That in itself raises questions about what the obligations of the seller are, whether they've any obligations in that regard. So moving on, next slide, please. And I think we can skip that one for now because we've already covered that. And so what sort of claims? So the two points I want to touch on in the remaining time are types of disputes under the LOIs and something about COGS of 1992. So first of all, the LOIs. So you may get breach of warranties, obviously, as to entitlement to the bills or the cargo, but a fertile sort of dispute is claims in misrepresentation or deceit as between the seller and the buyer, or indeed the seller and the buyer's bank, who will foreseeably have relied upon the LOI, even though not the addressee of it. And so one can contrast instances of the Trafigura and Cookman case, where it was said that there was a misrepresentation because the seller did have bills of lading available to it, albeit that they were non-conforming. And Mr. Justice Cook had no difficulty saying that was not arguable. the representation means not as to any old bill of lading, but conforming and valid ones. Contrast the Fraser Scandic, where a claim by the bank in deceit succeeded because there was a finding of fact that the seller and giver of the LOI had already granted property rights in the cargo and had no intention of obtaining or passing on the bills of lading, and the claim in deceit succeeded. And all sorts of issues arise on these sort of claims in the usual way of deceit claim, which is who foreseeably relied on it and whether there was actually inducement. And those give rise to all sorts of disputes. Next slide, please. So the second topic I want to deal with is the question of what happens if the bank or other party gets hold of the bill of lading and wants to sue the carrier for misdelivery. And it's usually vital that the holder can establish contractual rights under the English or Singapore COGSA legislation under the usual provisions. And numerous issues can arise in this context under these types of claim. First of all, the holder is only someone entitled to sue if they are holders in good faith. A relatively low bar, according to a GNC, limited to honesty rather than some broader concept of good faith. But in these contexts of these type of fraud, if the holder is privy to some fraudulent scheme, they may not be a holder in good faith. Then, secondly, you may get a break in the chain of title passing down under COGSA. So if, for example, the bills are non-compliant under one of the LCs higher up the chain, there may be a break, and that means that further down the chain, the holder is simply reliant on warranting the payment of LOI. Another reason why there may be a break in the train is if you get a mismatch between the identity of the endorsee and the identity of the party to whom it's delivered. So often the LC requires endorsement to the bank and the LOI requires delivery to the buyer. And unless the buyer gets it as agent for the bank, there may be a mismatch. Another possibility is exemplified by the Dolphina, which postulates that fraudulent conduct by the endorser itself, regardless of the good faith or otherwise of the transferee, may vitiate the endorsement. And that again was a case where there were LOIs on delivery, and that was a relevant factor in the lack of good faith of the seller, which prevented endorsement happening. Then finally, there is the question of whether the bill of lading is spent. That may not matter if Section 2.2 of COGSA is engaged and there's a relevant transaction before the time in question, but that's not always the case, particularly with letters of credit which may have been opened at a late stage in the proceedings. And this brings in all the old favourites. Clearly, discharge of the cargo itself does not render the bill of lading spent, but it may not be. It may be if the cargo no longer exists or has been dispersed, and it may also not be if the cargo is delivered to a person who subsequently becomes the bill of lading holder, thereby reuniting possession of the cargo with the bill of lading. And there are then other very interesting issues raised on questions of acquiescence by the bank. And with that, I'm going to pass the baton over to Mike after that canter through a number of the interesting issues that arise on that. And I'm going to pass on my last slide, which raises another interesting question, but that's for another time. So thank you for listening patiently, if you have been indeed, and over to Mike.
Richard, thank you very much indeed. As you say, we now move on to Mike Bools. And Mike has been in practice here in London in the areas of commercial law and advocacy now for some considerable time, as politicians say, and he has been also involved in cases in the British Virgin Islands and in arbitration as well. He deals also with issues of the conflicts of laws and jurisdiction, and is recommended in the legal directories in the fields of commercial dispute resolution and energy and natural resources. So, Mike, over to you for dealing with liability for misdelivery.
Thank you, Richard. Good morning or good evening, depending on which jurisdiction you're joining us from. As you will see, I'm going to cover two aspects of liability for misdelivery. The first being the possibility of contractually excluding any liability for misdelivery by an appropriate clause in the bill of lading. And secondly, the circumstances in which a carrier may successfully argue that on the facts, the holder of the bill of lading consented to or acquiesced in the delivery of the goods without requiring the presentation of the bill. Next slide, please, Paul. So, turning first to contractual exclusion contractual exclusion of liability for misdelivery. You'll see from the top line of the slide that is theoretically possible, provided there's sufficiently clear wording, and that comes from the Chartered Bank of India case, now over 100 years old. In that case, a cargo was delivered to the carrier's landing agents and lighted, and then the agents then fraudulently disposed of the goods without the surrender of the bill. And you can see the particular clause in the bill of lading was extremely widely drawn, and said that liability of the company should cease absolutely when the goods were free of the ship's tackle. And the Privy Council, Lord McNaughton, said they were sufficiently clear to exclude liability for misdelivery. That, however, was the high watermark, so to speak, if you'll pardon the pun. Next slide, please. This next slide relates to a case some 50 years after Chartered Bank ZI Tom. It concerned a similar clause where you had responsibility being deemed to cease absolutely after the goods were discharged. And at first blush, you would think that formulation wasn't materially different from that in Standard Chartered, but that's not how Lord Denning saw it. And he held that the wording was wide, but that it didn't exclude liability for misdelivery. He did that on two bases. He accepted that it could hardly have been more comprehensive, but he pointed out that, construed literally, it would absolve the company even if it had given the goods away to some passerby or burned them or thrown them into the sea. And he said that if you'd asked the parties, was the clause intended to cover such circumstances, they would have instantly said, of course not. And therefore, on the classic officious bystander test, he implied a limitation on the clause to exclude deliberate misdelivery without production of the bill of lading. Secondly, he went further and said a clause permitting deliberate delivery without presentation would defeat the fundamental object of the contract, namely that goods should only be delivered against the production of the bill, and therefore it couldn't be, as a matter of law, relied upon. Now, more recent cases have taken a similarly strict approach, albeit on reasoning that's subtly different. Could we have the next slide, please? This is an important decision of Mr. Justice Clark, as he then was in the INIS, and there are a number of points to draw out of this. First of all, he pointed out that in Swiss Atlantique, the House of Lords had explained ZI Tom essentially on the doctrine of what was then fundamental breach, that a fundamental breach brings the contract to an end, including the exclusion clauses. Of course, that was done away with in the 1980 decision in photo productions. But Lord Justice Clark was nevertheless undaunted, and he reasoned that delivery against and only against presentation of the bill was one of the main objects of the contract. And therefore, in light of that, as a matter of construction, the ambit of the clause had to be limited. Now, you can see the clause in question, after discharge, there'll be no responsibility whatsoever. But Mr. Justice Clark construed it very narrowly and said it only applied to the loss or damage to the goods and not to their misdelivery, even if deliberate. The next slide, please. And one sees a similar approach by Lord Justice Mance in the Motis export case. Again, you can see the clause at the top of the slide. Again, Lord Justice Mance said that as a matter of construction, it didn't cover misdelivery, despite the breadth of the language. And again, you see the reasoning in the quotation at the foot of the slide, very similar to that of Mr. Justice Clark. Even if it covered misdelivery, it's not a construction which should be adopted involving, as it does, excuse from performance of a fundamental obligation of such fundamental importance. And he goes on to say, matter of construction, court leans against the result if adequate content can be given to the clause. So although the sort of fundamental breach doctrine, which underpins ZI Tom and Lord Deming's reasoning has gone, you can see that the courts arrive at the same result by a matter of construction. The next slide, please. The final case that I want to draw attention to is a relatively recent case in 2009 from the Hong Kong Court of Final Appeal in the Carewinds case. That's interesting because you can see in the clause at the top of the page or halfway down the page that this case involved an express exclusion for misdelivery under no liability in any capacity whatsoever for loss or misdelivery. Nevertheless, the court held that the clause was capable of covering a range of misdeliveries, particularly including those that didn't involve a conscious disregard of the presentation rule. And it therefore said that the clause could be given meaning by construing it as only applying to those that did not involve a conscious disregard of the presentation rule, and it was therefore limited to those situations. So, in conclusion, one concludes that it is theoretically possible to exclude liability for misdelivery by a suitably worded clause, but there is great reluctance on the part of the courts to allow that to happen, and they have applied a number of methods to avoid it. Next slide, please. The next topic, which I'll have to take at something of a canter, is the question of acquiescence or consent by the holder of the bill of lading to delivery of the goods without production of the bill. And the argument you can see in the slide, which is usually run, is that although there is a breach of contract in delivering without production of the bill of lading, nevertheless, the holder may have evinced an intention to vary the contract, to waive the contractual obligation, or not to rely on its full legal rights, thereby giving rise to an equitable estoppel. But in each case, whatever route one is arguing, it's necessary in each case to show that there's been some communication from the holder to the carrier authorising or instructing delivery without presentation. The next slide, please. As you can see from the title of the slide, it rarely works, this argument. First of all, it's well established that knowing that the carrier might deliver against a letter of indemnity, for example, is insufficient to establish consent to delivery without production, because there's no communication to the carrier, and ex hypothesi, the reason the letter of indemnity is required is because delivery without presentation would in fact be a breach. Secondly, past consent or knowledge of previous deliveries without production of the bill of lading is insufficient to establish consent to a later delivery without presentation. And you can see two cases there from Hong Kong. And Starline Traders in particular is very striking, because the court said that in that case, there had been a whole series of transactions, and in 128 previous cases, the cargoes had been delivered to the same consignee without production of the bill of lading. But the court said, even assuming that the holder of the bill of lading in issue was aware of those previous 128 deliveries without presentation of the bill, that didn't evidence consent to a further delivery without the production of the bill. The third reason why these cases rarely succeed is that it is inherently improbable that the holder would consent to delivery without production of the bill of lading in the abstract. But if we could have the next slide, please. It is occasionally possible, and all I need to say about these two cases from Hong Kong is that the striking thing about them is they weren't cases where it was suggested there was a general consent to delivery without production of the bill of lading. In each case, there was an express consent to delivery to a particular individual without production of the bill of lading. I think my time is up. Many thanks.
Mike, thank you very much indeed for that very swift but illuminating look at those issues that arise in relation to attempts to get out of liability and attempts to get out of getting out of liability. Now, we're going to turn to our Singapore colleagues now, and it is really a great pleasure to introduce our two speakers from Rajah and Tann in Singapore. Of course, it's evening time there, so good evening to you. First of all, Toh Kian Sing, Senior Counsellor, who has great experience in bill of lading and charter party disputes and trade finance matters. And he is the senior or a senior partner and the head of the shipping and international trade practice at Rajah and Tann. And he's been a senior counsel since 2007. He also deals with joint venture disputes and particularly Sino-foreign joint venture issues. He sits as an arbitrator in Singapore and elsewhere. And I'm pleased to say that also he has joined Michael Bools and Richard Lord and me as author of the third edition of Bills of Lading. This book is coming out on the 23rd of December, so if you wish to pursue some of the issues which we're ventilating today, that's the place to go and look for the answers, we hope. Anyway, now over to you, Toh Kian Sing, Commodity Fraud, the Financier's Perspective.
Thank you, Richard. If I may start by just thanking Brick Court for organizing this joint seminar. Paul and his team has put in a lot of effort in bringing this about, and we are particularly grateful. Now, I have prepared the presentation from the perspective of the banks. There are many more issues in the PowerPoint presentation that I put together than I can sensibly deal with in the 15 to 20 minutes that I have. So what I propose to do is to just select a few points and elaborate on them. Now, next slide, please, Paul. Next slide. Thank you. Now, the three types of commodity finance financing that we encounter, there are letters of credit. These are the three common types: letters of credit, inventory financing or warehouse financing, including repo financing, and then the discounting of receivables. Now, these methods of financing are not new. They've been around for a long time. But precisely because they've been around for a long time, the inadequacies of these methods have also become well known to commodity traders. And over time, I think it's fair to say that due to competition, banks have also loosened up their financing structure. Now, these various factors have led to a number of fraudulent or perhaps undesirable practices, which I'm going to deal with next. So next slide, please, Paul. Thank you. Now, the first of this is something that Richard has alluded to earlier. That's circular trades. Now, circular trades without any underlying shipments have become quite common. Likewise, the related practice of sleeving. Now, in this regard, there are two Singapore decisions, both recently handed down, are quite illuminating. They both deal with the financing of oil shipments. Let me start with the second of these cases. That's the Goodwood and Southern Pack case. Now, it essentially involves a shipment of oil loaded on board a bunker barge. Now, Goodwood, the plaintiff in that case, sued Southern Pack for the purchase price. It basically acted as a credit sleeves. So in other words, it had banking facility and it extended the banking facility to the parties in the trade, and in the process made a margin. There's no doubt in that case, and both parties accepted that it's a circular trade involving a number of parties. And Southern Pack, the purchaser, took the view or advanced the argument that, in fact, this circular trade was a sham. It was a sham and therefore unenforceable, and therefore it didn't have to pay the purchase price to Goodwood. Now, the Singapore judge made a few important observations on circular trades and sleeving. She started with the obvious and fairly comforting observation that circular trades in and of themselves are not shams, right? There are very many reasons why commodity traders engaged in circular trades, one of which is sleeving, which happened in that case. Goodwood was a sleeved, and sleeving is sometimes necessary because participants in the commodity trade do not have sufficient credit facilities. And the judge said, well, that's perfectly fine. The other reason for circular trade may be that the participants want to take advantage of price fluctuations. And that, again, is perfectly legitimate. Now, but what is not legitimate, and that's when a circular trade becomes a sham, is if there are, in fact, no goods that form the subject matter of all these trades, or if there are goods, then the participants in that circular trade do not have rights or title to those goods, and they are not able to pass title to the goods from one party to another. Now, the facts of that case, the court held that, in fact, the circular trade was legitimate, and although there were false documents in the form of intertank transfer certificates, nevertheless, the court held that the sleeving party, the plaintiff in that case, was innocent, didn't participate in the fraud, and therefore the claim for price was upheld. Now, the Goodwood case can be contrasted with another recent case, that's the BWG case. Now, this is a decision which has also got to do with the financing of oil, purportedly loaded on board a ship. I say purportedly loaded because the court found in that case that the documentation coming from the ship was extremely sparse and extremely suspicious, and in fact pointed to the transaction, the underlying transaction, as one of a loan rather than a legitimate contract of sale. So on that basis, the Singapore Court of Appeal reached the preliminary conclusion that that was a sham. It was not a sale contract, it was really just a loan. But what's of particular interest to the banks, perhaps, is the fact that in this case, the loan didn't come from a particular party. The money was injected into the circular trade by an LC. So the party with credit facility was in fact the lender, but didn't come up with any capital. The capital came from the bank. And that's something which I think some banks would have to bear in mind going forward. Now, let me move on to the next slide, please. Okay, this is yet another form of abuse of letters of credit. Again, it's using what Richard earlier called lax documents for presentation under LCs in order to draw on LCs to provide short-term financing. This has been around for a long time. This sort of practice has been around for a long time, and in the last 3 to 5 years, it's been particularly prevalent because of interest rate arbitrage. Next slide, please. Fake documents, that's self-explanatory. Let me move on to the next slide. Now, Richard spoke earlier about payment letters of indemnity, or payment LOI in short. Now, I just want to highlight 2 points, 2 practices which I have come across quite frequently in the course of advising clients. The first of this is the use of payment LOIs when original BLs are present and available to be presented under the LC. You heard the earlier remark by Richard that the use of a payment LOI entails a representation by the beneficiary of the credit that bills of lading are not available at the time of presentation, and hence a payment LOI has to be used in its place. Now, if bills of lading and other documents are in fact available, then the use of payment LOI is in fact a fraudulent attempt to call on the LC. The question then arises as to why would a beneficiary not present original BLs and use a payment LOI instead? Well, there are a number of reasons why this may be the case. The more egregious of that is that such a party may intend to sell the goods down to another party and tender the original BLs under that other sale transaction. That, of course, it's very bad news for banks, but I have seen these things happen. And so, although payment LOIs are very common and they are almost always presented under LCs open for oil shipments, sometimes one must take a step back and ask if indeed the beneficiary is without the original BL, or is this a case where, for one reason or another, he simply refuses to tender the original BLs. And of course, without the original BLs, the banks would have eventually got to enforce their rights under the payment LOI to try to get their hands on the original BL. That may not necessarily be easy, And even if that's possible, the banks would have to face the risk that by the time the original BLs are available and endorsed to them, the time bar under the Hague or Hague-Bisbee rules of 1 year may already have expired. Okay, so those are the two practices which I like to draw to everyone's attention. Oh, sorry, I should have said that the other instance where payment LOI is used is where there are in fact no goods at all, and this is a manifestation of sham circular transactions. Again, it's not unseen, it's not unheard of rather, for beneficiaries to present payment LOIs and an invoice when in fact the goods were not sold under the contract of sale, and this entire structure is really just a fraudulent attempt to raise financing using letters of credit. Okay, let me move on to the next point. Next slide, please. Now, I've highlighted two risky or fraudulent practices that commodity players indulged in. Let me just touch on a couple of things which banks can do. Now, 20 years ago, the idea of a middle office doing due diligence on big ticket commodity deals was a strange one. But 20 years forward, most banks that carry out or that provide commodity financing on a big scale would have established its own or their own middle office. Now, middle office has the role of checking transactional details pertaining to a particular deal that the bank may finance. But beyond conducting due diligence on the transaction itself, there are a couple of things that I think that the banks can do to lower the risk that they would otherwise be assuming when they finance a cargo. Now, I have set out a number of these things that the banks can do to lower their risk, but let me just highlight two of them. Next slide, please, Paul. Sorry, the slide before this. Right. Now, if a bank is involved in the financing of oil shipments carried on board a floating storage unit, such as a VLCC sitting out in the oceans, the bank is often quite vulnerable to the movement of cargoes in and out of the FSU. And I have seen in many instances where the bank is unable to bring any claim for practices or fraudulent practices which the ship owner and the commodity trader perpetrated by the ship owner and the commodity trader. And that's largely due to a lack of a direct contractual relationship between the bank and the ship owner, the owner of the FSU. I would, in this regard, suggest to the banks that they should consider extracting through their borrower some form of contractual undertaking from the ship owner or the operator of the FSU. And a number of these undertakings are worth considering. First, the bank should get some kind of an acknowledgement, an atonement from the FSU owner that the cargo held on board the vessel is subject to the order of the bank in terms of movement in and out of the FSU. There should be some kind of direct contractual right enforceable against the FSU to provide periodic ullage reports. And finally, the bank should also make it a point to have a right to conduct independent ullaging of the oil that is carried on board the FSU. So that's one particular measure that the banks can take if they finance inventory, oil inventory carried on board FSUs. Next slide, please, Paul. Now, this is the last point I want to cover. Now, just late last month, the Association of Banks in Singapore published what is described as the Code of Best Practices for Commodity Financing. It sets out a number of practices which banks in Singapore are advised to take on board. And one of the key aspects of this code is increased transparency and increased control over receivables, the goods which are the subject matter of the finance, the transport documents, and it even covers payment letters of indemnity. Now, if one looks carefully at some of these practices, it's fair to say that they're all well-intended, but whether they actually can be accepted by commodity players or not is a matter that we don't have an immediate answer to, but time will tell. I would just want to end, given that my time is nearly up, by making one observation, which is that this code of best practices can be double-edged. If a bank does not adopt all of these practices and a loss occurs, is the applicant of an LC, i.e. the bank's own customer, able to turn around and say to the bank, well, you have not observed these best practices, and due to your negligence, I have suffered a loss. That's something for the banks in Singapore and perhaps elsewhere to ponder. And with that, let me hand the baton over to my colleague Kah Wah. Thank you very much, everyone.
Thank you very much indeed. It's a shame that we haven't been able to go on and consider issues concerning the fraud exception, but the slides are there. And if there are questions, then not only can you ask them at the end of the contribution of our next speaker, but you can also write in. There's plenty of scope for debate and discussion, and that can take place online. So last of all, but by no means least, may I introduce Leong Kah Wah, who is the head of dispute resolution at Rajah and Tann. He acts as lead counsel and arbitrator and mediator in cases concerning shipping, international trade, banking, and general commercial disputes. He also sits on tax tribunals, so a neat little sideline there. Now, Leong, you're going to instruct us on how it is that the Singapore court has moved away from the Aliakmon.
Thank you, Richard. Good evening, everyone. I'm happy to be able to share with you a recent judgment from the Singapore courts, which marked our departure away from the commonly known test of the Aliakmon requiring title to sue in a negligence cause of action. Paul, next slide, please. I tried to find a picture or an image of the Aliakmon, but this is the best I could do. Next slide, please. Just in case you are rushing off to a lunch appointment or to the viewers from our part of the world, a dinner appointment, the two takeaways from my presentation are here, right? So under Singapore law now, title to sue in negligence, right, title to and possession of the damaged property at the time of the damage is no longer a requirement. So we have departed away from the Aliakmon rule. And that the second point is that pure economic losses are recoverable. And with that, feel free to file actions in Singapore. We would be very pleased to assist you, right? Those who have claims that require a more liberal view on the causes of action. Next slide, please. The name of the case is Wilmer Trading and Heroic Warrior, reported at 2024 SLR, Singapore Law Reports, at page 357. It is a first instance decision of Justice Belinda Ang. The facts are quite straightforward. The plaintiff is an FOB buyer, and the plaintiff is also a voyage charterer from a sub-time charterer down the chain, and the defendant is the owner. So as you can see from the first bullet point, there is no privity of contract in the charter chain between the plaintiff and the defendant. What happened was that during loading, right, and due to overpressurization in the cargo holds, due to clearing of the lines after loading in a certain tank, the tank top cracked, right? So the cargo already loaded on board then had to be discharged and transshipped. So no BLs were issued as the loading was not completed. Right? So the plaintiff claimed cargo damage, cargo shortage, as well as loss of use of their voyage chartered vessel. Next slide, please. So the plaintiff's case is that they argued that there was a contract, express as well as implied on the basis that if bills of lading were to be issued, there would have been a contract. And secondly, the main focus of their case really is on negligence, and that the defendant, the owner, owed a duty of care to a FOB buyer, the plaintiff in this case. Next slide, please. The defendant's case on the issue is that since there were no BLs, even if it was issued, it would have been time-chartered BLs and not owner's BLs. Right? And the second point on title to sue is that the plaintiff has not paid, the plaintiff has not acquired ownership or possessory rights to the cargo at the time damage was suffered, citing the Aliakmon. Next slide, please. This is the decision of Justice Belinda Ang. She agreed that there was no contract, and for negligence, and to find that a duty of care exists, the test is one of proximity. There should be factual and legal proximity. And then are there any policy considerations, right, that would negate the finding of a duty of care? She cited the NTU Seafood Fair, a Court of Appeal decision also quite recent, 2018, and that the Aliakmon principle in NTU Seafood Fair was said to be not a part of our law. And it is a part of English law, and it was a part of English law because it was to exclude pure economic loss under English law. So it required a claimant to have proprietary or ownership or possessory interest in the chattel that has been damaged. But under Singapore law, right, since the decision of Spandeck, another Court of Appeal decision in 2007, pure economic loss is recoverable, and hence there is no basis for the Aliakmon principle to exist. Now, the NTU Seafood Fair case was not a shipping case, right? And this was the first instance that Justice Belinda Ang said that it would nevertheless apply, right, to a shipping case, and she declined to follow the Aliakmon principle, and she followed the Court of Appeal decisions in NTU Seafood Fair. Next slide, please. So the finding that was that there was a duty of care, right, and that the duty of care existed, right, in terms of proximity, right. Factually, it is reasonably foreseeable that its negligence, the owner's negligence, would cause economic loss to a FOB buyer who bore the risk. Right? The buyer had nominated the vessel, and in terms of legal proximity, the relationship between the owner and the FOB buyer was sufficiently proximate because risk had passed on loading on board and owners had possession over the vessel. And in terms of policy considerations, this won't be an indeterminate class of claimants. The FOB buyer having being the sole party with risk was clearly an identifiable plaintiff. Right. So in terms of breach, the court went on to find that there were structural weaknesses in the ship's holds, and that there was a crew failure to control the manifold valve, and that led to the tank to crack. And these failures were the defendant's failures to provide a cargo-worthy ship and also to take care of the cargo while loaded on board. Next slide, please. The observations that I gleaned from this case is that first, I think Singapore law, right, is quite progressive and is ready to examine basis of legal propositions if the circumstances justify it. So, in other words, going forward, when you have tortious causes of action, it would be important to look at what is the applicable law to the tort. Right? In this case, it was a case where it involved loading in Indonesia, right? And if parties had known that this would be a relevant issue, then it would have considered whether foreign law, being from the natural forum, would be an applicable law. And parties, I would say, going forward, please do bear in mind that there's a difference between the Singapore law and the English law on this aspect. The second point I wish to make is that this is a rather rare situation because most of the time cargo claims are covered by the bills of lading, right? And in this instance, there is no bills of lading because loading has not been completed and the BLs have not been issued. If they have been issued, right, there is a contractual framework, right? The Hague or the Hague-Visby rules would govern, and that you wouldn't be left to fend with just the tortious realm. And that the last point I wish to make is that this being a first instance decision, but nevertheless is well supported by two earlier Court of Appeal decisions, and there is no reason to apply a different test for shipping cases. So my own observation is that this would signal that in future for cargo claims, and if there's a claim solely made in tort, this would be the applicable law to take home. That's all for my presentation today. Thank you for your patience.
Thank you very much indeed. Well, I think that decision raises an awful lot of issues. And can I start off the questions by just asking a very simple one? Is it going on appeal?
Richard, an appeal was filed, but the parties have settled. So that remains the last word on this case.
That's terrible news for the lawyers, I think. But there we are. Now, we have a number of questions that have been already put in by various attendees. One indeed was put in yesterday. But I'm going to start off with asking this question, and I think it probably goes to Richard Lord, as it was asked in respect of the issues that he was dealing with. As regards the risks raised by you, Richard, the attendee asks, would it make any difference if bills of lading are digital? Very topical, and we know that the Law Commission is looking at issues concerning digital bills of lading at this very minute. So, Richard, have you got any thoughts on that?
Well, the short answer is that I believe that digital or electronic bills of lading will solve many of the problems in relation to competing rights to cargoes, and that is indeed one of the benefits that their proponents push forward. So the short answer is yes. The longer answer is that the real expert on this, or one of the real experts, Miriam Goldby, has also written an extensive section on this in our book, which reaches the same conclusion but in much greater detail. So yes, it's not a universal panacea or silver bullet, but it reduces or can reduce these problems. So that's my short answer.
Thank you very much, Richard. Now, a question that was raised amongst a total of 6 that was sent in by email yesterday from one attendee. And obviously, unfortunately, we can't deal with all of those questions today online in this conference, although they are very interesting and I'm sure can be discussed by email. But I'm going to pick out just one, just the third of these 6 questions. And the question here concerns financing against warranty of title and the question is it more risky than financing against letter of indemnity? And the second part of the question is, how can fraud be prevented when financing DES/DAP terms for cargo? Now, I wonder, Toh Kian Sing, whether you have can give us some views on those 2 parts of that question.
Richard, happy to. I think the starting point is that this distinction between LOIs and payment LOIs and warranty of title, WOTs, it's an important one. Now, standard WOT wording does not provide banks with as much protection as standard payment LOI wording. Richard Lord gave us a very good dissection of the common terms that one would find in a payment LOI earlier on in his presentation. And you'll see that one of the common terms is that the LC beneficiary comes under an obligation to exercise reasonable efforts to locate the BLs and to surrender those BLs to the buyer, i.e. the applicant of the LC, and when the BLs are surrendered, typically they come to the bank as the bank has security over the bills. Now, and WOT does not have, usually does not have a similar, usually does not have similar provisions, and so the duty of the LC beneficiary is that much watered down. So that's one point. The other important thing to bear in mind is that in a DES shipment, very often bills of lading may not be called for, although they can be, depending on what the LC says, depending on what the sale contract says. So when a bank finances a DES cargo, it has to bear in mind the additional risk that it takes on board if the LC and or the sale contract does not call for the presentation of original bills of lading. Thank you, Richard.
Thank you very much indeed. That's extremely helpful answer. But what it does show is that there are there are problems that need to be addressed. Now, the third question, and I think probably the last that we have time for, is one that considers the possibility of reform. And the question is, should legislators consider recognizing a document of title in respect of FSU, that is stored cargoes, to preclude the need for getting an atonement every time? I don't know whether we have a volunteer from amongst the panelists who would like to tackle this particular question. Any volunteers for dealing with that one? Not a ready volunteer. Well, can I start then by saying it should be thought about whether it's as easy to do as all that. I very much doubt. But the notion of atonement is quite a clumsy one, and I think the questioner is right in saying that this is something which produces difficulties if you're going through a number of possible sub-sales. So to do something which precludes the need for getting that every time sounds sensible. Whether it's easy to do, I don't know. And whether or not life would be easier if you had digital bills of lading or other documents of title, then I suspect that the problem might go away, as Richard Lord was suggesting just now. Would anyone like to add any comments to my rather elementary statements? Michael.
The point I would make is that one, of course, would be talking about a document of title at common law, or rather, let me express that differently. What one would be talking about in terms of a document of title, if one's talking about a document which is capable of passive constructive possession, then theoretically one could legislate to give a document relating to a cargo on an FSU the same effect as a bill of lading would have under common law. But I suspect what the questioner is really getting at is, well, yes. I mean, Kian Sing was saying what matters is that there's a contractual relationship between the FSU holder. I'm not sure that it would be necessary to achieve that to make the document a document of title. But presumably what one would be looking for is a document that was capable of transferring contractual rights by way of a similar mechanism, for example, that operates under COGSA. But it certainly it's something that would be worth considering. Sorry, that was rather garbled.
Thank you, Mike, very much. Well, I think that's all that we have time for in terms of additional questions. So can I just finish this conference by thanking all our speakers in the UK and in Singapore for their contributions, for the way in which they have prepared their slides so meticulously, and they are well worth going back and looking at again. Thanking also Paul Gray for organising this conference and setting it up with the aid of the IT departments, both here in Brickcourt and at Rajah and Tann. Can I just say that the conference is being recorded and so can be looked at and listened to again, And as I mentioned earlier, if anyone wants to send in further questions, then the panel will be very willing to try and answer any questions that might be produced. And for my part, I think I'm going to go away and look again at the Aliakmon question in particular, because it's something which has turned up in one form or another throughout the time that I've been in practice, which is now far too long for me even to think about. Anyway, thank all of you who have attended and joined us this morning or this evening, and I wish you either a very good afternoon or a very good night.